In the second place, these defendants, by their voluntary participation in this program, with full knowledge of the criminal methods used in recruitment of forced labor, are guilty of the crime of deportation and of the murders, brutalities, and cruelties committed in connection with such recruitment and deportation. The evidence will show that the defendants knew well the manner in which this labor was being recruited. In fact, they made every effort to participate in it directly by sending their own representatives to the occupied territory. As to the voluntary nature of their participation, it need only be pointed out that no employer in the Third Reich was assigned labor against his will. He had not only to ask for the allocation of labor, but his success in getting it depended on the pressure he could bring to bear on the allocating authorities. The enterprises under the control of these defendants were eager, aggressive, and successful in their efforts to obtain workers from all sources involved in this criminal program. The individual firms besieged their local labor office. The Berlin office of the concern was in constant touch with various officials of the ministry connected with the administration of the program. Finally, pressure was brought to bear directly on Staufel, Speer, and others at the top of the Nazi hierarchy by means of the powerful self-administrative associations of industrialists, such as the Reichsvereinigung Eisen, RVE, for the iron industry, and the Reichsvereinigung Kohle, RVK, for the coal industry. They were responsible for the death, inhumane treatment, and suffering of the workers while employed in enterprises under their control. The entrepreneur was responsible for the well-being of workers on the job. True, he was circumscribed by government regulations as to the amount of pay, the food ration available, and in certain other details. But the primary responsibility for the health and well-being of these unfortunate workers belonged to the owners and managers of enterprises. We shall have occasion to see how these defendants discharged that responsibility. We turn now to a discussion of the evidence to be presented on this count. Reports from both Hartner and Essner show that by 1944, over half of the entire labor force came from foreign sources. These same statistics, in many instances, carry separate columns indicating the number of prisoners of war employed. A comparison of the statistics with reports prepared in the Flick front office from 1942 to 1944, showing the contribution of the Flick concern to the war effort, proves conclusively that prisoners of war were used in the manufacture of armaments. For example, shell casings were made at Gruditz, ammunition at Freital, and armored cars at the Linke Hoffman works. During this period, the employment statistics show that in January 1944, 1,145 prisoners of war were employed at Gruditz. In December 1943, 671 were employed at Freital, and in July 1943, 1,017 were employed at Linke Hoffman. The concern and its Berlin office, from the outset, was eagerly interested in taking advantage of all sources of the new labor supply. Scarcely a month and a half after the invasion of Poland, prisoners of war were arriving for work at Max Hughes. Whenever an additional source was made available, the Berlin office was careful to inform the various companies what steps were necessary to get their share of the new laborers. We find Kuttner, Burkhardt's assistant in Berlin, conferring with officials of the Labor Ministry in June 1942 concerning the acquisition of Russian and French laborers.